Hey everybody, Andy Nelson. So I want to answer a question I get quite often, which is what does public domain mean? What is public domain? And this is why it's important to you as a business owner and hopefully a holder of different sorts of intellectual property that make up part of your overall value. Now I say intellectual property, and yes, the word property is in there because we know that some intangibles, not physical things like the stuff you see around me or the real estate, but intangibles are given property-like qualities, or the law treats certain things as having property-like characteristics, these intangibles, which makes them intellectual property. And certainly in the column of your property and your business and owns your real estate or real estate holdings or leases or whatever it is, your personal property, that third column, intangible intellectual property, is certainly something that makes up your overall company value. But public domain, what is that? Usually what we do is we usually find public domain being used in connection with patents and copyrights, a little bit less in the trademark world, but in the patent world, what does that mean? The phrase you'll hear often is you got to do X, Y, and Z with your invention to try to get it patented, or it's going to fall into the public domain. Now, what that means deeper is if you got some sort of innovation, invention, and you've done something to trigger a particular bar, we'll call it, or a timeline. Usually if there's some sort of disclosure of your invention, whatever your idea is, and I won't get into the details because it can be complicated, but if you trigger certain deadlines and if you don't meet those deadlines to apply or begin the patent process, your awesome innovation is going to fall or could fall into the public domain, meaning you're not going to have the opportunity to assert those rights over it anymore. So that's public domain as it applies in the patent world. When it comes to the copyright world, it can mean a couple different things. Typically, public domain refers to just old stuff. Copyright protects works of authorship. So what that means is it may be literary works, it may be graphic art, fine art, photographs, it may be musical notation, sound recordings, sculpture, architectural plans, all sorts of expressive works. And those items, when they're created, enjoy copyright protection for a long, long time in the US and a long time in most other countries. But if things are old enough, they go back. They're in the public domain. If you want to make copies of the Bible and sell them yourself, it's in the public domain. You can do that all you want. Older works from the 1800s, even things like, say, Moby Dick or something like that. I don't know off the top of my head. I'm pretty sure it should be out of copyright, so you can make all the copies you want. Those are public domain items. Currently, there are things that have been created in the last 75, 100 years are likely not going to be in the public domain. It's a mixed bag. It's not easy to figure out what is in the public domain and what's not. When it comes to copyright, but usually, if you go back before 1900, you're going to be pretty clear. The product or the work is going to be in the public domain. You're going to be able to use it. More recent things, not so much. If it's a government-created work, it doesn't own copyright, so that may be in the public domain. And some things that even get created now, authors contribute them or commit them, if you will, to the public domain and make them free for everybody to use. But at any rate, what it means ultimately is works that are not protected by any sort of intellectual property protection. In this case, I'm talking about copyright, and then would be free to use by others. It's in the public domain. Trademarks, it's not really a term that's used often in the trademark world, but I guess if I'm going to say it's something, it's going to be, look, if something is something kind of distinctive marker, whether it's a word or a name or a slogan or color combination or whatever, if it hasn't been adopted for use to identify a particular source of goods or services, such that someone's built up trademark rights in that distinctive thing, it's probably fair to say that it is in the public domain and it's there to be adopted by somebody and kind of taken out of the public domain if that distinctive thing takes on trademark significance. Then it starts to acquire or take on property rights in the form of trademark rights, and then it's not in the public domain anymore, at least insofar as that mark applies to or is used to identify certain goods or services, but it may be in the public domain, if you will, to be used for other goods or services that wouldn't cause consumer confusion and therefore create trademark infringement. So anyway, That's it, public domain in a nutshell. If you have any questions about this video, shoot me a note, drop a comment, and if anybody would benefit from what was in this video, please feel free to share it. Until next time, we'll see you soon. Bye-bye.